Okay, good afternoon, good morning, or good evening, ladies and gentlemen. My name is Kun Fan. I'm an associate professor at UNSW Law and a member of the Herbert Smith Freehill CIBEL Center. I'm very delighted to welcome you all to our final session of CIBEL Global Network Conference. I'd like to begin by acknowledging the Badagat people who are the traditional custodian of the land where UNSW Law stands. I would also like to pay my respect to the elders, both past, present, and emerging. Today, we are very pleased to have a panel of leading experts from a variety of jurisdictions who will cover a number of topics related to COVID-19 and digitalization of dispute resolution. Each speaker will talk for about 10 minutes, and then we should leave for about 20 minutes in the end for Q&A. So the audience can pose your questions in the Q&A function. So let me first start by briefly introducing the topic. As we know, the COVID-19 pandemic has certainly caused significant impact on public health and global economy, but it also imposes great challenges on the administration of justice. Justice delayed is justice denied. Access to justice is one of the biggest problems facing the legal profession today. Some call this problem as inaccess to justice pandemic. And there is a big gap between people's understanding of their right and enforcing their right. So we all need to think about ways to bridge that gap and thus to improve access to justice. But when we talk about access to justice, we also tended to focus narrowly on dispute resolution in the courtroom. But as Mark Gallanter pointed out, justice health is not found primarily in hospitals or knowledge in schools. So justice is not primarily to be found in the courtrooms. Ultimately, access to justice is not just a matter of bringing cases to a fount of official justice, but of enhancing the justice quality of relations and transactions in which people are engaged. Indeed, access to justice could and should be much broader. According to Richard Susskind, access to justice should include not just dispute resolution, but also dispute containment, dispute avoidance, and even legal health promotion. This is indeed also consistent with Confucius' ideal of harmony and conflict avoidance. Long before law was established, where courts were organized, where judges had formulated law, parties resolved their dispute informally outside the courtroom. Singapore's Honorary Chief Justice Manon said, "We need to shift our thinking and see ADR not just as an alternative to traditional court system and process, but as an essential element in a range of tools that are able to be found in a complex and rich toolkit that is available to resolve the dispute." So the better term might be appropriate dispute resolution. This pandemic has certainly pushed for more demand for ADR, including mediation, conciliation, other amicable methods, as well as the mixed mode dispute resolution. As business tries to reopen, parties may need to focus on rebuilding their relationship, renegotiating the contract, and finding alternative ways to resolve their conflicts rather than insisting on strict enforcement of contractual terms, as the other side might be exempted from performance with force majeure defense or become insolvent. At the same time, the pandemic is also exerting greater pressure for the arbitration community to find innovative ways to incorporate greater use of technology through more ODR or virtual hearings. Indeed, many leading arbitration institutions have already issued guidelines and tools to facilitate virtual hearings. But when the entire evidentiary hearing is conducted virtually, a number of issues could also arise, such as due process, cybersecurity, data protection, confidentiality, language, to name just a few. Courts around the world are also adapting to find remote alternatives to traditional hearings to ensure ongoing access to justice. Richard Susskind is probably one of the earliest advocates for online courts. In his book, Tomorrow's Lawyer, he questioned, is the court a service or a place? As we shall see in a moment from the experience of Chinese internet courts and DIFC courts, there seems to be a gradual change of mindset from court as a service to from court as a place to court as a service. It also shows a mindset change from focusing on the system to focusing on the needs of users. The needs of users may actually push for a healthy competition between the courts, arbitration institutions, and other ADR service providers to provide more efficient services, which will in turn improve administration of justice. Having said that, we should also not lose sight of the human element of the courts and arbitral tribunals, which involve human sentiment, human reasoning. The Federal Court of Australian Chief Justice also said in a 2019 speech that the court is not just a service, nor is it just a place. It is the embodiment of judicial power and the guardian of the rule of law. This power is the manifestation and application of equality before the law, impartiality, the rights of a party to properly ventilate and respond to disputes and allegations against them, and the fair and, as far as possible, correct determination of question of fact in the law. And these are not deducible to statistic and matrix and are not fully digitizable. Indeed, in the Asian local courts in China, the board pending facing those local magistrates read as 天理国法人情, meaning natural law rules, national laws, and human sentiments. So this human sentiments still play an important role, even in judges' decision today. So when we consider this digitalization process, we should also bear in mind those human sentiments and the limitation of AI in terms of valued judgments, human sentiments, and emotions, and thus the need to set proper boundaries. So in today's panel, we will discuss many of the issues that arise in online mediation, online arbitration, and digital courts. And we have divided our panel into 3 sessions that will focus on online mediation, arbitration, and digital courts respectively. So we will start now from our first session that focuses on online mediation. And our presenter is Professor Carrie Shang, who is Assistant Professor of California State Polytechnic University. She's also here with her co-author, Dr. Wenli Guo, Director of Beiming Software Corporation. My question to our first panel is that, well, undoubtedly, that COVID-19 pandemic has led to a significant increase of mediation, including a growing acceptance of online mediation. But in this context, what role do public and private stakeholders play towards promoting a wider acceptance of online mediation initiative around the world? And what lessons can we learn from the experience in China and the US? So Carrie, the floor is yours.
Thanks very much, Professor Fan, for the very insightful introduction. So my name is Carrie Shang, Assistant Professor, California State Polytechnic University. Today it's a very great honor of mine to be presenting some of our thoughts of the development and regulation of online mediation under the COVID-19 pandemic in the United States and the People's Republic of China, 2 of the largest world economies right now, which we hope to address some of Professor Fan's questions just now to see the role of different public and private stakeholders in promoting a wider acceptance of online mediation. And it is very unfortunate, but an emergency scenario calling for a lot more innovative solution. So this particular, my presentation will be based on a recent paper. First, it's forthcoming in the World Arbitration Mediation Review, actually next month, which is an in-house review of Florida State University. So my presentation will be closely structured and under the order of the paper. So if you're interested in some more detailed discussion, you can probably try to seek the paper and have a more detailed reading. So everything really started because this very unfortunate pandemic situation, and there's this worldwide country lockdowns and social distancing orders, which have drastically impacted behaviors of dispute resolution. Namely, it's just no longer to do face-to-face dispute resolution anymore. So in this period, online mediation ODR have really undergone a lot of developments in both United States and China, although the development has in both countries a little bit different. So in China, where the pandemic really hit a little bit early, because China was the first country that was hit by the pandemic, on February 18th, China's Supreme People's Court, SPC, issued a notice on strengthening and standardizing online litigation during the prevention and control of the novel coronavirus pandemic, mandating that all court levels in China actively test the use of online dispute resolution, establish online mediation platforms, and ensure the availability and quality of ADR measures. So in this paper, we observed three significant improvements in China in the field of online mediation. First one is the expanded scope of ODR. Second, increased participation of private online mediation providers, leading to a more fierce market competition. And thirdly, stronger push towards a nationwide online mediation regulatory scheme. So regarding the first point, expanded scope of ODR, we give the example of Zhejiang High People's Court, which was the first court in China to adopt a online annexed ODR platform. So during and after pandemic, it really has launched 7 specialized online mediation platforms covering a wide range of disputes, including property, financial, online lending, environmental, administrative, and the use of online mediation platforms has increased rapidly. So according to the data that was given by the SPC Information Center, between February and March, Chinese courts of all levels have conducted nearly 150,000 pretrial online mediation. That's an astronomical figure considering the short period we're discussing. Further, from January 23rd to March 13th, number of new user visits to the Zhejiang ODR platform reached 249,901, with over 20,000 newly registered users. So you can see ODR has really become a vibrant thing during this pandemic, attracting a lot of new users and active users. And second point, there's also increased competition. A lot of private mediation players entering the field, creating a mediation service market that is going to modernize and transform the mediation scene in China. And third point, there's also the stronger needs towards stronger regulation. For those of you who are familiar with the Chinese law and Chinese tradition, there's a perception of institutional authority that is always directly linked to perception of justice, which means that anytime there's a movement towards regulation, it's basically a symbol of authoritative credibility. So giving a lot of more credibility by conducting centralized regulation. So the need for a lot of efforts towards improving regulation of online mediation in China really symbolize that is a formal recognition of online mediation as a form of important ADR in China. So moving to the United States, where the entire ODR scene developed very different from China. We know the United States is very, very badly hit by the pandemic. It's still in the midst of pandemic. Everything really started in early March. A lot of ODR platforms have already been exercising or have been experimenting training of online mediators around early March. That was very quick community response to the needs of the market. So some very prominent mediation service providers, such as the GEMS and CPR, have conducted courses trying to improve technological competence of online mediators. And there's also a lot of concerns, active compliance. So those standard setting organizations, including ICODR, National Center for State Courts, and ABA, have promulgated new rules or have revised their own rules in order to improve active compliance of mediators and also legal professionals. Confidentiality really come up as a concern during the pandemic because increased use of online mediation platforms. Some of the most salient controversies during the pandemic involve the use of platform of Zoom, which is one of the most popular online video conferencing tool that went from a high of 10 million users per day to a daily average of 200 million users in March 2020 overnight. So it was skyrocketing, very successful company, maybe the most successful company out of the pandemic fog. But there are a bunch of security issues that have been raised by mediation practitioners as Zoom gained more popularity and publicity. These issues ranging from Zoom bombing, illegal recording, to unauthorized sharing of user data, and also backing up some of its data outside the United States, violating some local privacy issues. So those inquiries really lead to some possibilities talking about Zoom replacement, at least in the field of online mediation, in order to relieve some of the confidentiality concerns. So those are some of the overall observations in the two countries during the COVID-19 pandemic. But as a legal academic, what I'm primarily more interested in is the role of states and public-private stakeholders leading to promoting wider use of online mediation during the global pandemic. I think there are two things we need to emphasize here. First one is the different perception of ADR, ODR in both countries, and second one is a different role of states. So ADR, as we all know, in Western culture and also in common law jurisdictions, are really considered as a access to justice alternative, which started in the United States, at least in the 1970s, as a partial solution to litigation exclusion. So the categorization of ADR method in common law traditions has always been private and informal, so that the development of online mediation in the United States, at least during the pandemic, is really community-led. So leading by this bunch of ADR professionals that are recognizing the need and potential of its field to embrace advanced technologies through self-embraced efforts. In China, it's entirely different because the role of ADR is different. The development mediation in China has never fully disposed of its public function, and therefore the function of social governance is always an inseparable part and goal of a mediation in China that is not observed in most Western nations. And that dimension was very evident during the pandemic, also because of the citizens' expectation of the Chinese state to take a lot more responsibility, to act faster, to provide sufficient mandates and guidance to direct the development and use of ODR. We're not trying to argue for or against in any manner, because both countries have been able to see a lot of improvements of the use of ODR. But we're just trying to remind the audience this distinction between a state-mandated or community-based methodology. Even though we believe that probably both have the potential of promoting online mediation during and after the pandemic. And that was my part. Thanks very much.
Thank you very much, Carrie, for the very insightful presentation on a very interesting topic. I'm sure we'll come back to you with some questions. And now I will move on to our second panel that focuses on the impact of the pandemic on arbitration. We have three speakers in this panel, which hopefully also bring in some different perspectives. The three speakers are, in the order of their presentation, Dr. Tietie Zhang, who is a lecturer in corporate commercial law of University of Sheffield School of Law, Mr. Guillermo Garcia Pejote, Senior Associate of Herbert Smith Freehill, Sydney, and Mr. Yuan Fang, JIC Candidate and Research Assistant of Washington University. So I will start with a question for our first speaker, Tietie. I wonder if you can give us a general introduction about what impact does the COVID-19 have on international commercial arbitration? To what extent it will reshape international arbitration? And also, what are the important legal issues that the parties, councils, and arbitrators should be conscious of with the digitalization process? So Tietie, the floor is yours.
Okay, thank you very much, Professor Fan, for the introduction, and also thank you and all the other organizers for the hard work in organizing this terrific event. I'm very happy to be here. To be honest, I would personally prefer visiting Sydney in person, but obviously, given the circumstances, this virtual conference is absolutely the best scenario. But I very much look forward to visiting Sydney in hopefully the very near future. Okay. Here I'm going to quickly talk about share some of my thoughts on the evolvement of arbitration during and also after the pandemic, and particularly how arbitration responds to or adapts to and to the pandemic and how it will evolve afterwards. My overall observation is that the pandemic has undoubtedly brought a lot of challenges to the arbitration, but also many opportunities at the same time. Okay. On the challenges part, I think that's relatively easily understandable. The COVID-19 pandemic has undoubtedly brought challenges to all the corners of the world, to everybody, to every activities that we engage in, including, of course, arbitration. And we're talking about delays in the proceeding because people cannot meet, they cannot travel, or they cannot even go to their office. So that's, I'm sure, I don't think I need to spend too much time on that. But at the same time, I think overall there are a lot of new opportunities for arbitration. And my projection is that we will likely see an increase in the usage of arbitration in the future. I have two reasons for that. Okay. First of all, what I think we will for sure see is an increase in the disputes, in commercial disputes after the pandemic. This is due to the disruptions caused by the pandemic and also caused by the economic downturn and recession caused by the pandemic. Okay? And these commercial disputes will need resolving. Okay? So in other words, from the supply side, okay, the market for dispute resolution just became bigger. The second reason is that I think arbitration, comparatively and relatively speaking, is in a good position to deal with the disruptions and difficulties brought by the pandemic, especially compared with the litigation. In other words, of course, arbitration is facing a lot of challenges, but at least it's, comparatively speaking, less affected, or in other words, in a better situation than litigation. Two quick examples. Number one, this is largely the situation is largely caused by the fact that, for example, litigation is a public good and arbitration is a private process mechanism. I'll give you two quick examples of that. Number one is, for example, the arbitration is flexible. Right? The proceeding is flexible, and that is one of the features, important features of arbitration, and actually why a lot of people choose to arbitrate in the first place. So as long as parties agree, they can reach an agreement, they can basically alter the detailed procedures to be adopted in an arbitration, of course, subject to due process and public policy concerns. But they largely, they have a lot of leeway in structuring the proceedings to deal with the difficulties caused by the pandemic. And also, I'm sure my co-panelists will elaborate on those fronts. And also, for example, the arbitration institution is also playing an important role in actively assisting with parties and arbitrators and lawyers in finding solutions to deal with the difficulties. Ever since the pandemic, we've seen a lot of famous arbitration institutions issuing very creative guidelines and policies in an attempt to help with help with everybody involved to deal with the situation. There is even I think a coalition formed by a number of arbitration institutions to make pledges that they will try their best to make it happen. So all in all, I mean, altogether, you can see that arbitration will likely become even more popular after the pandemic. But obviously, arbitration cannot stand still. Okay? So we have seen a lot of measures being taken by different parties. Most importantly, by taking advantage of the available technology. We're talking about everybody switching to, for example, electronic submission of documents. Virtual hearings has been very popular during the pandemic. Many of these technologies are not necessarily new. They have been in place for some time, but due to a host of reasons, they have never become the mainstream of how people do things until pretty much right now. The pandemic is definitely a big driving force in pushing towards those agendas, adopting virtual hearings, for example, as much as possible during the pandemic, when it's probably the only viable option. However, I think many of these technology-based new measures, including virtual hearing, may still stay on being popular even after the pandemic, because people involved may just find them convenient. Right? It saves a lot of cost, saves a lot of hassle from traveling. So it may become popular even after the pandemic. So that's the changes we're talking about. So my projection is that blended arbitration is going to become popular in the future. By blended arbitration, I mean a traditional arbitration process combined with online features, virtual features. I don't want to use the word online arbitration or the ODR, because that concept may potentially be a little bit misleading, because a lot of people refer to online arbitration as those arbitration proceedings that happens completely online without any physical attachment. I don't think international arbitration is going toward that direction, although I think it will be popular to have a sort of a combination between the physical and virtual world. Okay? So blended arbitration, my projection is will become popular in the future. But because it is as I said, a combination, it certainly does have a physical procedure as its backbone. I think there are a lot of legal issues that all parties involved need to watch out for. Right? Basically, because the blended arbitration still need to fit in to the existing legal framework for arbitration, right? So we're not only talking about the arbitration proceedings themselves, we're also talking about the interaction with the judiciary, with the courts. Right? So issues like enforcement of arbitration agreements, enforcement of arbitration awards will continue to be important. So therefore, a lot of issues, and because the blended arbitration, there's online features, under those circumstances, some legal issues may become quite tricky. So I think that parties involved will need to watch out for them. I have a few quick examples. Number one is seat of arbitration. We all know that the seat of arbitration is a very important concept, right? It directly decides on the law governing the proceeding of the arbitration, right? And also what court enjoys jurisdiction to review the awards, so on and so forth. So it's the seat of arbitration may become more tricky in the blended arbitration setting, because obviously you have more places involved, and therefore I think it's important that party reach explicit agreement in their arbitration agreement, and if they haven't done that, the arbitration institution, arbitration tribunal need to make a determination as early as possible in the proceeding. Okay? Some of the other issues include, for example, another issue is due process. That's also very important. It relates to the enforceability of the award. In online arbitration, the virtual hearings, you probably need to be careful about has the party been properly notified? Does the party have sufficient opportunity to present their case? Right? Will there be any procedural defects related to virtual hearings, so on and so forth? A third example is confidentiality and cybersecurity. Obviously, privacy and confidentiality, these are very important issues to think about, and people need to be very careful with. Okay, I will stop right there because as my time is up, and I look forward to the discussion later. Thank you very much.
Thank you very much, Tie, for your presentation. You raised a few interesting questions that I'm sure we will probably discuss later in the Q&A. And now moving on to the Council's perspective. So I'd like to ask Guillermo, from your experience, how do you see the pandemic has changed the way arbitration is conducted? What's the situation like before COVID-19, what it is like now during COVID-19, and what's your prediction about the future of arbitration post-COVID-19? Guillermo, please.
Thank you so much, Professor Fan. It's really a pleasure to be here with all of you. And again, thank you so much for organizing this wonderful conference. It's great to be able to collaborate with practitioners all over the world. And I especially think it's always great when practitioners collaborate with academics. It brings a very, very good combination to every discussion. So to answer your question, I'm going to break down the situation before COVID, during COVID, and after COVID. So what was the situation before COVID? So before COVID, we were seeing an increasing use of video evidence in arbitration. And obviously, this was subject to requirements of fairness and due process. And straight off the bat, let me really stress that we were all very careful with those requirements. And there was a big effort in ensuring that everyone was comfortable in the way that video evidence was given. But the general view, let's be very transparent about this, was that it was more appropriate only for more marginal witnesses. In other words, not key witness or not key evidence. That was the general rule. And other than that, it was when a particular reason justified the fact that a witness could not be present for many different purposes, because the witness was working for another company, for example, was overseas, and so on and so forth. And especially when credibility was not an issue, when it was not contested. So we can say that in general, it was used for marginal witnesses or witnesses in a position of difficulty traveling to the hearing. And that was the situation before COVID. During COVID, obviously, things changed very rapidly. It has been a huge catalyst for change in terms of virtual hearings. And we've seen a transition substantially towards a full virtual hearings. And we're seeing that across the board, and obviously including cross-examination of witnesses. And this is obviously also supported by the fact that major arbitral institutions have quickly reacted to this new reality and the restrictions to movement and travel. And they've all published guidelines, such as for example, ICC guidance note on possible measures aimed at mitigating the effects of the COVID-19 pandemic. And we are seeing everyone, practitioners, users, institutions, technology providers, translators, adapt very quickly in this regard. And looking to the future, what is a post-COVID arbitration going to look like in terms of hearings? Well, let me start by saying that there was, and there still is, some skepticism as to whether the shift towards online hearings can be permanent. It's widely accepted that they are appropriate and necessary, at least while the restrictions are in place. And what is going to be the view when those restrictions are lifted is very much an open question. My personal view is that we are going to very much see a new normal, with virtual hearings very well become the rule and the general practice. The view is obviously not universal, because certain practitioners and commentators are worried about the fact that in some cases it might be preferable from a due process perspective, for example, and predominantly dealing with cross-examination, to defer the hearing. Why? Well, in those cases, it's because there are issues around credibility, because counsel, opposing counsel is not amenable to cross-examine remotely, and because basically the parties cannot agree, and there are issues around how the cross-examination is going to take place. Obviously, online hearings or virtual hearings are a very sensible measure to avoid delay and to ensure that the resolution of the dispute can progress. And in this regard, what I think is consensus position is that COVID has been a catalyst for change in the sense that it has accelerated the speed where right now practitioners, institutions, and parties are very comfortable in going to a virtual hearing. And perhaps that was going to take a few years, if not decades, to actually be mainstream, and now it's happening as we speak. So focusing before we go on to the next panelist, and obviously we can discuss further in the Q&A session, I thought it was useful to discuss the cross-examination and some of the concerns that I've been mentioning. So basically, in terms of witness examination, there are key components here to the discussion, including the location where the witness will be giving the evidence, the requirements even as to the position of the cameras, so everyone can see where the witness is giving evidence, to ensure that if he's being assisted by, for example, counsel, that everyone knows who's in the room and that everyone is comfortable around how the proceedings are going to proceed, right? And in terms of issues around credibility, I think it's useful here to refer to case law that we already have. And in this regard, there's a significant volume of case law which already provides guidance on the attitudes that courts in leading common law jurisdictions especially have around cross-examination via video link. And we can mention a few decisions, especially in England and Wales, in Australia and in Hong Kong. And the fact is that national courts are already increasingly open to the use in litigation of online hearings, particularly obviously in the context of the current pandemic. And there have been a number of decisions, and I'm obviously happy to elaborate on this if we have time later on in this regard, that basically show that courts are not shy in ensuring that proceedings move along as long as parties can ensure minimum requirements as to credibility, as to how the witness examination is going to take place. And obviously, just to finish with this, in arbitration, things are much easier because we all have much more flexibility to arrange the process. Arbitrators have broad powers and broad flexibility to resolve any concerns regarding cross-examination. Almost more importantly, counsel typically cooperate well and effectively in this connection. So you normally see counsel from both sides cooperating well and effectively in ensuring cross-examination by video conference. And now that we're seeing an increasing use of technology, more protocols, more sophistication, I expect that trend very much to continue. And with that, over to you again, Professor Fang. Again, it was a pleasure, and I hope we can discuss a little bit further in the Q&A.
Thank you, Guillermo, for your sharing. And again, quite a few interesting points that I also have questions to follow up, perhaps if we have time in the Q&A session. And now I'd like to move on to our third speaker, Yuan. Hopefully to share with us a bit of the institutional perspective, because in Yuan's paper, he also co-authored with Yan Wang, the case manager of Beijing Arbitration Commission, and did some insight research about arbitration institutions in China. So I wonder, Yuan, if you can share with us about your research, how do major arbitration institutions in China react to COVID-19? How are the arbitration rules adapted to the COVID-19 situation? And what are the challenges facing Chinese arbitration institutions during the pandemic? Yuan, The floor is yours.
Yeah. Thank you, Professor Fan. I'm very pleased to join today's panel discussion on digitalization of dispute resolution. And following the discussions brought by Dr. Zhang and Guillermo, I expect to provide an institutional perspective to the arbitration issue here, sharing with you some experiences gained from the practice of major Chinese arbitral institutions in the midst of COVID-19. So this presentation selected several most influential and reputable Chinese arbitral institutions from a variety of them. The institutions to be analyzed here include International Economic and Trade Arbitration Commission, or CITEC in short, Beijing Arbitration Commission, BAC, Shenzhen Court of International Arbitration, SCIA, and China Maritime Arbitration Commission, CMAC. So the major Chinese arbitral institutions act proactively in response to COVID-19 and gained valuable experiences from their practice during COVID-19. While their success is embodied in various aspects, this presentation will in particular explore 4 of them that have shown the most distinctive achievements in this unprecedented time. So the 4 aspects to be introduced here are online case filing, online exchanges of case documents, virtual hearing, and partial award. So I'll start from online case filing. So traditionally, the majority of Chinese arbitration institutions conducted the case filing process in an offline form. However, the outbreak of COVID-19 pandemic led to the closure of offices and therefore indirectly facilitates the Chinese arbitral institutions' shift from on-site case filing to online application. So CITEC is one of the leading arbitral institutions in China that made this vital change. In fact, CITEC already developed an online appointment system for case filing prior to COVID-19, though the parties were usually still required to file their cases at its offices. During COVID-19, CITEC started to encourage the parties and their representatives to file their arbitration applications with the CITEC online case filing system. So despite the use of online case filing system, CITEC reserves the option for the parties and their representatives to use postal service or other non-contact means to submit their arbitration applications. So in the meantime, CITEC also clearly indicates that this offline to online shift is temporary. And after the office facilities of the CITEC headquarters and its submissions reopen to the public, case filing at its offices may be accepted with the necessary anti-epidemic measures in place. So, and similarly, SCIA also takes full advantage of its online case filing system during COVID-19. SCIA is dedicated to the construction of a safe and convenient online arbitration platform for the parties. To better serve this aim, SCIA drafted the guide on case filing to provide specific instructions for the parties to successfully file cases online. So the SCIA guide on case filing is primarily an introduction to the basic procedures of online case filing, including account registration, case information input, confirmation of service address, case materials upload, final submissions, etc. Since June 1st, 2020, SCIA is reopened for on-site case filing. However, for safety concerns, the online case filing option is still highly recommended by SCIA. In addition, CMAC and BAC have also offered the online option for the parties to file cases during COVID-19. And except online case filing, the online exchanges of case documents mark another accomplishment of the major Chinese arbitral institutions during COVID-19. Actually, institutions like CITEC, SCIA, and CMAC have already recognized the demands of electronic submission and service of documents, even prior to COVID-19. Specifically, CITEC allows for electronic communications by email, EDI, or any other similar means between CITEC and the parties in an online arbitration. SCIA admits the validity of both the electronic submission of documents to SCIA by the parties or to the parties via CIA. And similarly, CMAC also allows for electronic submission and service of documents in the context of online arbitration. CTEC has further expressed its encouragement for online exchanges of case documents by stating that the parties are encouraged to agree to submit and receive arbitration documents via emails for the purpose of promoting efficiency in service of documents. Furthermore, the parties are always encouraged to agree on submitting and receiving arbitration documents via emails in any stage of the arbitral proceedings. And in terms of virtual hearing, despite all the major arbitral institutions in China have more or less touched upon this area, BAC and CTEC made rules specified for virtual hearing in the midst of COVID-19. BAC provides a comprehensive framework for the whole process of virtual hearing. The key points worth being highlighted are the following. Regarding the scope of the application, it is specified that virtual hearing is applicable when one or more parties cannot be present due to epidemic prevention or other objective reasons. The parties have the needs of cost control, or the hearing is supplementary to the previous one. Concerning the pre-hearing preparations, equipment test is required in order to avoid any technical interference to the virtual hearing. And the parties should cooperate with the institution to electrify the materials required for the hearing. With respect to the procedures of virtual hearing, the institutions and the parties are required to familiarize themselves to the platforms to be used in order for the smooth implementation of virtual hearing. Compared with BAC, CTEC focuses more on the arbitration participants' manner during the virtual hearing. For example, CTEC stipulates that the parties, arbitration agents, and other arbitration participants, when taking part in a virtual hearing, shall be free from interruptions and with good illumination and network signals. Additionally, CTEC also demands the arbitration participants to dress properly when participating in a virtual hearing and shall ensure that their heads and faces are fully shown in a reasonable area of the screen. Finally, with regard to partial award, the mechanism of partial award is not new to the major Chinese arbitral institutions. Instead, it is a long-standing practice by them that began far before the outbreak of COVID-19. Partial award is typically tailored for the cases where a part of the facts involved has already become clear. Under such a circumstance, the arbitration tribunal may first make an award in respect of such part of the facts. For instance, CTEC stipulates that the arbitral tribunal may first render a partial award on any part of the claim before rendering the final award. And the partial award is final and binding upon both parties. BAC also stipulates that the arbitral tribunal may render a partial award disposing of particular claims before the proceeding to render the final award. SCIA and CMAC have adopted similar rules in relation to partial award as well. The importance of partial award in protecting the parties' rights under COVID-19 is being realized by the major Chinese arbitral institutions. As a result of COVID-19, a variety of arbitration participants are faced with severe financial crisis. Thus, there is higher demand for the efficiency of arbitral proceedings. In spite of the relatively high efficiency compared with litigation, the ordinary arbitral proceedings may still be too time-taking to the parties during COVID-19. Accordingly, CTEC encourages the arbitral tribunals under COVID-19 to consider the feasibility of rendering a partial award when it is not ready for a final award yet, but it's possible to have any part of the claims to be decided first. So above is my brief introduction to the practice of major Chinese arbitral institutions under COVID-19. Thank you.
Thank you very much, Yuan, for a very interesting sharings. So now I will move to our final panel that focus on digital courts. And on this panel, we have two speakers. Again, in the order of presentation, our first speaker is Associate Professor Mimi Zhou, who is Reader of University of Reading Law School and co-founder of Oxford Deep Tech Dispute Resolution Lab. Our second speaker is Ms. Amna Al-Awaz, who is the Chief Registrar of Dubai International Financial Center Courts. So now turning to our first speaker, Mimi, she will focus on the experience of the Chinese Internet Court. As we know, China is at the front line of the use of technology in the court services, with the increasing adoption of AI tools, blockchain, and smart contract in the case management and also adjudication process. Millions of cases are now being decided by those Chinese internet courts without even citizens having to present in person. So, I mean, from the experience of the Chinese internet courts, what can we learn from those experiences? And also, what do you think will be the most effective ODR process look like in the future? Perhaps you might also want to share with us the experience of the Oxford Dispute Resolution Lab, which sounds also quite interesting. So Mimi, to you.
Thank you so much, Professor Fan. Or if I may say, just Kun, just because you're a friend and colleague for many years, and I'm just so delighted to be part of this very topical but also very stimulating panel so far of very distinguished speakers looking at different aspects of dispute resolution in the current crisis that we face at the moment, and possibly in the foreseeable future. Unfortunately, things are getting worse, unfortunately, here in this part of the world. In the UK, infection rates are rising, and our courts are, I think, really under significant challenge to not only deal with the backload of cases in the last 6 months, but obviously also as a previous speaker said, the disputes that will be coming, the avalanche of disputes that may be coming because of the pandemic. So today I really want to focus on, I guess, not so much the really sexy stuff, which is you know, can robots be judges? I think that's a very interesting topic, and I don't want to go too much into the details of the technical aspects of how technology is being applied in Chinese courts. I will mention some of the technologies that have been used, which is at a much more advanced level than we see in, for example, in the UK and other countries. But I think what the pandemic has shown us is also the possibility for the legal profession, which has been very resistant to change as a whole. You know, when you think about legal tech as an industry, it is behind other industries like fintech, like health tech, and ed tech. And so what is it about our industry that makes it so resistant to change? And I think ODR is an interesting area to look at, because while you have a lot of advancements in, say, contract management, contract review technologies, and other aspects of legal tech that applies to more transactional work, I think the speakers before me have highlighted some of the challenges, particularly around due process, that perhaps remote hearings that cannot achieve. But of course, ODR, as you know, is beyond just remote hearings. And I can already gain from some of the speakers that, you know, if you really want to see transformation of the court system, it can't be court system 2.0, right? So technology is not about basically digitalization of judicial services. We have to think about some of the underlying goals of our justice system and how technology can actually facilitate those goals. So one of those goals, for example, is the sort of all-important goal of access to justice. And that is a goal that we see driving a lot of reforms towards digitalization in the courtrooms around the world. So in the Chinese context, we know that Chinese courts hear about 20 million cases a year. That's 20 million cases a year. And, you know, many of you who have friends who are judges in China, like I do, know that a junior judge in Shanghai Basic People's Court in, you know, a busy district will hear about 250 to 350 cases a year. That's a lot more than what judges in Australia or the UK would typically hear in a year. So I think the judicial reforms that we've seen in China in terms of the drive towards technology under this framework of smart courts, which was announced by the Supreme People's Court in 2015, certainly has access to justice as one of its goals. Obviously, the caseload on judges, many judges in China, are always complaining. At least my friends, my judge friends are complaining about the workload, and it's hard. It is not an easy job to be a judge. At the same time, in addition to alleviating the workload on judges so that they can produce quality resolutions, it is also a public good in terms of providing access to justice to many people who might not be able to physically visit a courtroom, who may, because of a disability, or they live very far from the courtrooms. So I think, this access to justice by putting things on WeChat, the micro courts, you can actually log in. Many courts have set up even before the pandemic. And these are not just internet courts. Of course, the internet courts, which I'll go into in a minute, are the sort of the poster childs of the Chinese efforts to digitalize dispute resolution in the judiciary. But beyond the internet courts, what we see are actually many courts now, and this is going to accelerate because COVID has shown us the possibility that it can be done quickly, that you will be finding more courts be able to, all you have to do is download an app on WeChat and then basically take a screenshot, just kind of, and that will verify your identity. You can log into your details with your citizen's ID card, scan it, and then just upload, evidence. And this can all be done within seconds, right? And within some of these platforms, the court can undertake at the initial stage mediation. So I absolutely agree with you, Kun. We can't think of the courtroom as just litigation these days, putting in claims. ADR is a central feature of the multi-door courtroom. And so in China, we know that kind of court-directed mediation is a prevalent feature of the what is called a diversified dispute resolution framework, which is the Chinese kind of saying for ADR, the policy saying for ADR. So I think this is very important to recognize that we can do all of this stuff on a phone. And I've been talking to obviously colleagues around the world with my lab about sort of the possibility of using technology just to help facilitate better access to justice, particularly for claims that are not particularly complex, maybe low value claims. A project that our lab is currently working on is a project with the UK Ministry of Justice and our industry body in technology, Tech Nation. And it is trying to build a ODR platform for debt recovery for small, medium-sized enterprises. So debt recovery is a perfect example of the smaller claims that keep us awake at night. If you ever run a small business, or even if you're a lecturer doing a consultancy and you're trying to chase up money that's owed to you after issuing the invoice 6 months ago, we know that it can just cause so much time and energy, and you don't want these kind of claims in courts. Right, so this is an example of the sort of cases, the sort of civil claims that can be moved outside the courtroom. And so now I turn to the internet courts with the remaining minutes that I've got. I think this is a perfect example of the Chinese courts thinking very strategically, look, it's internet cases. Why can't we just kind of deal with all of this online? They have 99% of cases solved online. Of course, if the cases are not resolved online, it's not that, that's it, sorry, you can't have any other options. It's important that obviously claimants in the internet courts are able to take their disputes then to a higher level court. So the internet courts basically ensures that the millions, the tens of millions of e-commerce disputes or copyright infringement disputes that happen online are actually dealt with in a very quick and efficient manner. And that basically, it removes a whole millions of cases from the main court system. So I have a minute left. I think I just want to kind of provoke provoke the audience a little bit and ask the question of, I mean, the Chinese model is a very unique model. It has this regulatory framework, and it's very top down. It's been driven by the very, it's been driven by the leadership. And it is probably hard to replicate what they have done in terms of the digitalization of their virtually entire judicial system. Even criminal trials, which you think judicial process is very important, AI, machine learning, there's a lot of controversies around whether in criminal trials biases of humans are replicated as machines basically cannot really, that the data that they're trained with is as good as the data we give them. So I think I just want to raise the question to the audience whether you see a future with courts run by robots, and whether that's something that can only happen in kind of systems like in China, or you could see this in the rest of the world. Thank you very much for having me.
Thank you very much, Yimi, for the very interesting presentation and the big question raised really for us to reflect upon. Hopefully we have time to maybe in the discussion. Now I would like to turn to our last speaker, Amna, who will share us with the DIFC court's experience. As technology has always been central to the DIFC court's operation since it started operating. So I'm quite curious from your insight, what led to the DIFC court to implement such a robust technology strategy over a decade ago? And also, how did the DIFC courts deal with this pandemic, especially with the physical closure of the premises? And what kind of technologies are you looking at right now to boost the innovation of services? Amna, the floor is yours.
Thank you, Professor Fan, and thank you for inviting us to be part of this excellent platform. So for some of you who might not know the Dubai International Financial Center courts, we are a common law court. We operate in English as the center is an international center. So the common language is English language. We have judges from around the world. We have Emirati judges. We really work on making a difference in terms of the judicial industry. The DIFC courts has 4 pillars. We always work on those parameters. Judicial excellence, where we have experience of judges from around the world that spans for more than 350 years of experience. We have service excellence. As an opt-in court, as a court of choice, we focus on the journey of litigators, parties, giving them the best service available. As a 5-star court, it's really important for us to treat our parties equally and make sure that we look after their interests from a service perspective. We also have connectivity. Connectivity is really important for a court, whether from a technological perspective or even with having relationships across, borders. So DIFC courts, we believe that we are one of the most connected courts in the world for 3 reasons. The first reason is being part of a civil law country, we have the advantage of having automatic usage of all of the conventions, the Riyadh Convention, GCC Convention. So that gives us a huge network in terms of enforceability. Second of all, as a common law court, all other common law countries, or let's say judiciaries in common law countries, automatically honor our judgments. And last but not least, as a court, we started connecting with different jurisdictions, making sure that our judgments are enforceable. That comes without saying, of course, a court judgment is enforceable. However, we wanted to make sure that users are having the trust and certainty that the judgments will be enforced. At the end of the day, you need to convert judgments into money. Innovation, and that's, I would say, is our main discussion today. The DIFC court is very fond of technology and making sure that it helps in the journey of judicial excellence and service excellence, as it's a catalyst in making sure access to justice is available to everyone equally. So I would say in terms of the DIFC courts, we have been working on the digital transformation since the early days. Since 2009, we built our internal case management system. We created our e-registry. E-registry basically making sure that parties are encouraged to file documents and open cases electronically. At some point, we wanted to really encourage our users, and we had a surcharge of 40% extra. If you decide to file a claim, hard copies or face-to-face, you are going to incur 40% extra of fees. And that was our journey since the beginning. We were always encouraging our users to use the technological systems available. So 2009, CMS, e-registry, then we went into the courts of the future. In 2017, we created the courts of the future, out of which is a think tank of making sure we have the latest discussions in terms of how technology can help access to justice. Under that platform, we have the courts of the blockchain with Smart Government of Dubai, working on how we create that talent pool in terms of how blockchain really can help enforcement for courts. The same thing with paperless courts. I would say more than 95% of our procedures are paperless. And we've been working on making sure that we are paperless from the outset, even before the COVID-19 actually hit, the whole world, I would say. So for us, before and after COVID-19, the DIFC court has always been paperless, has always been encouraging virtual hearings and so forth. So I would say for us, the pandemic was more of an opportunity. It made our users realize that the world can actually continue even if you are online, even if you are from a virtual platform handling your business, handling your cases, whether it's judges or users, businesses, lawyers. It's really important that now they understand that actually things can happen virtually. We are connected and we can do everything from a digital platform. So with COVID-19, we continued our operations as usual. As Professor Fan said, it's just merely rather than being in the physical location, we became even more embedded in the virtual platform. Hence, we see this as a major opportunity, and we're working easily and smoothly in operating all of our cases virtually and paperless. And I'm very happy to be part of the session today and happy to take any questions as we go further. Thank you so much, everyone.
Thank you so much, Amna, for sharing with us the very interesting experience from the DIFC courts. And I want to thank all the speakers for the great presentations, which are very insightful. So I'm sure that really raises a number of questions for us to all reflect upon on the role of future courts, arbitrators and lawyers, and the role of robots, right? The role of AI. So now I would like to open the floor for questions. So you can pose a question in the Q&A function. I might just throw probably the first question following up to the question that Mimi raised, on the role of AI, as AI is getting increasingly involved really in the digital courts in China and also in elsewhere. But it certainly could, provide very important assistance to the delivery of justice to improve efficiency. On the other hand, some cautious about this technology utopian, right? So there are limitations of AI in particular. As I mentioned earlier, courts are still essentially human institutions, right? So there are limitations about value judgment, for instance. So to what extent do you think we could accept AI prediction as a binding judgment? And how far will AI go, and where should we set the boundaries? So Mimi or Amna, if you want to jump in on this.
Oh, I'm happy to start first and just kind of respond to a very, again, always provocative question from you, Kun. I think it's a great question. You're giving me another 5 minutes to speak. No, I'll just take a minute. Essentially, I think, as I've said, in terms of the less complex, low value, high volume cases, debt recovery. You know, it's not really rocket science. It's not really legal science in the sense that it may be disputed, but you know, certainly I think I would feel much more comfortable in a case where I'm just basically chasing up debt that is owed to me, for that process to be automated. I'm actually, as a user of the courts, I would be absolutely fine knowing that, you know, that could be automated and take millions of cases outside the court. I think it's much harder for many other cases, but having said that, you know, the smaller claim monetary disputes are really represent a majority of cases in the civil courts. So I think the use of AI at this stage and into the future will only be used in a facilitative way to help access to justice. It will not replace judges, because we know that, you know, there are many other types of cases that, you know, the importance of empathy, for example, is needed when you're giving out sentencing, you know, to a someone who, you know, may have a very complex background and also may fall into certain demographic groups that are more likely in the past, or, you know, in the data that we have, they were just, you know, subject to longer sentencing, and that's without the fault of the individual in front of you, right? So I think justice has to be at that individual level when we're talking about you know, the criminal cases, but also in the high value and more complex commercial disputes involving, I don't know, 20 international parties. It is unlikely that AI will replace the adjudication of humans, but certainly what I'm talking about is processes. What can be, so in China, you know, AI has been used to help litigants, you know, these chat boxes that chatbots that, you know, you can just go online. These chatbots know about answers to about 40,000 civil procedure rule questions, right? So that's simply a matter of knowing something that, I mean, of course they can, you probably don't need AI, but it obviously is in a way that you can interact with the bot, which makes the experience like you're almost talking to someone. Judges in China are also using AI to scan large volumes of documents to find particular pieces of evidence that can help them. So again, it's all facilitative, it's all helping judges do their jobs better.
So if I may just add, in addition to Mimi's points, we look at technology more of as an enabler for the judicial system and the judges. It increases efficiency. We never like look at it from a pure perspective of, oh yeah, judges will become replaced by robots. It's more of facilitating and making sure that the services of a court is actually maintained and enhanced and improved. Courts need to be looked at as a service provider and not just a place, more of a service provider like, you know, airlines, like hotels, a court that can be depended upon once needed. We're like a doctor. We are there. We like people to know that we're available if they need us, but we wouldn't want, you know, anyone to come and use the court, because at the end of the day, it's about maintaining business relationships and making sure you know, the economy is thriving and is successful. From our side, we also launched the Courts Tech Lab in Q4 of 2019, and that is to create an incubator, to create a testing hub for solutions that can help improve the judicial system. And it's not just you know, created to help the DIFC court. It's more about creating a platform where startups can actually come and use our ecosystem to improve and create new solutions that can actually be used by other court systems and by other jurisdictions worldwide. So at the end of the day, we look at the digitalization and the technology more as a catalyst and enabler for improving the judicial system, and rather than looking at the system as an intimidating place where we always thought of courts, oh, it's that scary place that we actually want to avoid going to. It becomes more of a designer court, more of a court that actually can assist and maintain and give trust to the business community.
Thank you. I see that, so maybe there's a question raised from the audience. So there's some question about the virtual hearing, the scale of the pushback of virtual hearings. It seems that it's not a major concern in the States, but what about, you know, the situation in non-US common law jurisdictions, perhaps civil law jurisdictions? And there was a separate issue about technological competence of the judge, which is also an interesting question. So I'll probably throw the first question about, you know, what's the pushback? Is there any pushback about this virtual hearings? Guillermo, you have mentioned about a few examples of UK, Australia, and Hong Kong. Do you want to elaborate a bit on that?
Thank you so much, Professor Kuhn. So very interesting question, actually, because it may be counterintuitive, right? The question suggests that perhaps in civil law jurisdictions, there is more pushback than in common law jurisdictions. In my experience, that's not the case. That's not the case. So we are generally seeing, again, good cooperation among counsel, whether they come from common law or civil law backgrounds. Actually, when we are seeing pushback, it's more from the senior barristers used to getting a very long cross-examination and making sure that they get into that rhythm, and their concerns around not being able to do that for key witness remotely. So, and just a brief point on that, in many civil law jurisdictions, the culture around cross-examination is obviously there in international arbitration, it's always there. However, their court systems, their national courts, the cross-examination is quite limited. So you traditionally don't have that culture of long cross-examinations. So therefore, I would suggest that the fact that there's not so much pushback is not very surprising in that regard, because you don't have that cultural tradition to start with. And in terms, just to finish, users, at the end of the day, users, in my opinion, are the most important part here, right? The corporates, the clients trying to resolve the dispute. They generally want to resolve the dispute. They generally want this to go ahead. And this facilitates things very much. And over to you, Professor.
Thank you, Guillermo. And indeed, I've noted also that there is a recent decision in the Australian Federal Court, the Capic versus Ford, in which the federal court actually noted the public institutions such as court must do all they can to facilitate the continuation of the economy and essential services of government, including administration of justice. And then concluded that the virtual hearing should proceed because adjournment indefinitely will not serve public interest. So that leads to a related question that I have is, you know, so can, in the context of COVID-19, could arbitration institutions be considered as essential service? Another issue, a question could arise is if one of the party or both parties object to proceed with virtual hearings, could arbitrators still proceed? How to balance the parties' right to present their case and, on the other hand, arbitrators' duty to conduct arbitration expediently? Does any panel, other panels in arbitration want to react, Tie or Yuan?
Yeah,
I will.
Okay,
sorry,
after you go first.
Okay, thank you. Just a couple of thoughts on that question, and also on the previous one. I think some of these, you know, proposals, virtual hearing, and also the thing that Professor Fan just mentioned, these are new ways of doing things, relatively speaking, right? And they, I mean, at the end of the day, they carry inevitably a certain amount of risks. From the arbitration's perspective, I think one important feature for everybody to think about is well, arbitration is not necessarily the final step, right? If there is a dispute, people want to challenge the award, there will be a second look before a court, right? And then that's why I think many of the practitioners, the arbitrators, the arbitration institution, they all want to be as safe as possible in conducting their procedures. They want to avoid any, potential problems when the award comes under review before a court. And that's why I think it's understandable that people want to be as careful as possible. So inevitably, although these new ways of doing things are promising, and I think everybody can agree on they can be very useful in many circumstances, people inevitably are concerned because they just want to be safe. And that's why we talk about cross-examination in virtual hearing. Practitioners, arbitrators probably think about, are we doing this in a perfect way? Can we avoid any potential challenge later before a court? And also the same thing as to what Professor Fan just referred to, if the parties have not yet reached an agreement on a virtual hearing, should the arbitrator order one? Right? I think people are going to be very careful with that. Obviously, you may check on the arbitration rules, right? If the rules specifically say that the arbitrator have the power to do so, of course, the arbitrator will be in a much better position, in my opinion, to make that decision. Although I don't think as the current arbitration rules of the institutions specifically refer to that power. They may have given some wiggle room. They may have some languages in there that may be interpreted as giving such power, but I don't think they're explicit enough at the time being. Of course, in the future, maybe there will be changes to the arbitration rules, realizing the situation, want to give that power to the tribunal, which is completely legitimate. But again, before that happens, I think people are going to be want to play safe for the time being.
Yeah, and I want to add something. So notably, there are some tensions between the existing arbitration laws and the rules of the institutions in terms of virtual hearing. Like actually, Article 39 of the PRC arbitration law challenges the legitimacy of virtual hearing, and it also raises the question of how much weight should be given to the parties' consent in determining the commencement of virtual hearing, which is also mentioned by Professor Fan. And so most of the major arbitral institutions in China just naturally assume that virtual hearing is legitimate, and they will give more weight to the parties' consent in the determining. They will give more weight to the arbitral tribunal in determining the commencement of virtual hearing, which is potentially a violation of the existing arbitration laws. However, when we look at the practice of the jurisdictions beyond mainland China, like other international arbitral institutions, they tend to recognize the arbitral tribunal's authority in the determination of virtual hearing, which is actually similar to the practice of the major Chinese arbitral institutions. So in this way, maybe it is the current arbitration law that should be amended rather than the practice of the arbitral institutions in China. And this is my observation. Yeah. Thank you.
Guillermo, do you want to react to that question as well?
Thank you so much. Yes, I just would like to make two very quick clarifications. The first one is arbitration is very much a final dispute resolution mechanism. You get a final and binding decision. The fact that you then have to enforce the decision is the same as with a court judgment. So I just want to clarify that point. That is very much a final one. And second, dealing with the powers that arbitral tribunals have today, I don't see a need to modify those powers or clarify. They do have those powers. They can make those decisions. And the fact that we are under the so-called due process paranoia, where every decision is thought through the lens of is this going to be challenged later on, that doesn't mean that you can make the decision in the first place. Courts can and are making those decisions in Australia, in Hong Kong, in England. Arbitral tribunals can and certainly are making those decisions as well. Are there challenges of every procedural step or every decision made by an arbitral tribunal? There can be. That doesn't mean that the arbitrator doesn't have the power to actually decide to go ahead. So I just want to clarify those 2 points.
Thank you. We have another question, perhaps our time for the last question on the cybersecurity concern. This is certainly of a concern, I think, for both mediation, arbitration, and the digital courts, very important issues. I wonder if Carrie wanted to share some thoughts about how to deal with cybersecurity, in particular in mediation, where confidentiality is quite important.
Right. I don't have a lot of like many examples, but I think Zoom has been dealing with this public relationship crisis pretty well by making some decisions or severing its relationship with certain jurisdictions by being able to attract consumers from other jurisdictions. There are a couple of lawsuits that are actually pending in U.S. courts related to challenging particular way of Zoom sharing its data and things like that. So we'll have to probably watch for its development in order to be able to conclude a bit better to say that. I'm just I think just to like to emphasize the way that I view this issue, at least in the United States versus China perspective, is that in the United States, you really do need this kind of law responses from the community in order to make something happen. Whereas in the States, or in China, people are looking for like regulation being there, preventing something to be happen to stay safe. So I guess it's like very different ways of doing things. But this concern is going to be something that would have to be resolved one way or another in order to make sure that users can be a little bit more comfortable with online vehicles resolving disputes in all matters. Thank you.
Thank you. Thank you, Carrie. I think also we have a final question is on this technological competence of judges, which is also quite an important issue. So should the judges, I guess the question is like, should the judges be expected to, be technological competent to handle this complex technological new issues like the use of AI, etc. So Mimi or Amna, do you want to react to that?
Yeah, I believe like being part and living in the 21st century, everyone is expected to be digital savvy. And of course, judges are supposed to familiarize themselves with, using technology, which actually makes their lives much easier. Let's say for international judges or even arbitrators, rather than traveling from one place to another and incurring fees and costs and such, process, it's better to actually be, equipped with the technologies available. And today it's like so straightforward. It's really simple to use technology, as long as you have the most important thing is to have a really strong Wi-Fi or internet broadband. Apart from that, I would say everything is supposed to be easy and available to everyone, including judges. It might have been just a habit, I would say. Maybe some of our, more senior judges are used to paper, hearings and doing everything physically. However, as soon as they would immerse themselves in digital solutions, they would actually realize, oh, actually I was missing a lot, and it's much easier, and it's such a relief that I can do everything remotely, maybe even while I'm at my holiday. If I have an urgent application, I can do things quite easily, especially with e-bundling and so forth. So I would say if not all judges are equipped, they're supposed to be, and with the recent pandemic, everyone actually had to, and the conversion was quite straightforward and easy.
Thank you. Thank you very much. So I note, thank you everyone for your presentations and participation. I know we are close to the end of the session. I'd just like to conclude by quoting Alan Kay, the best way to predict the future is to invent it. So a lot of things that we take for granted today might actually seem impossible 20 years ago. I remember when I worked at the ICC International Court of Arbitration about a decade ago, the default method of submission is still by hard copy. So we receive tons of folders, right? The lawyers attend the hearing with a suitcase of files. And we even have lawyers who took the train from London to Paris just to deliver those documents in hand. But today, certainly everything is already digitalized, and virtual hearing is becoming more common. And perhaps it won't be long before the virtual hearing will become the default, unless there are compelling reasons to conduct those hearings face-to-face. And we don't have to travel around the world to attend all those interesting webinars, like what we are all doing right now. Right? So I guess we just have to really prepare ourselves to the change of the future. The greater and better use of technology is an inevitable trend in the administration of justice. But the pandemic may just have pushed forward this digitalization process much faster. So arbitrators, counsels, lawyers, judges, courts, arbitration institutions should all prepare themselves for such evolution and to make the best effort to facilitate the just resolution of dispute as quickly, inexpensively, and efficiently as possible. So I'd just like to end by thanking all of our speakers for your contribution. Thank you everyone for joining us today. My special thanks goes to the OG Meet and TDM for kindly helping us to promote the event. And my particular thanks to my colleagues, Fion, Jane, for their assistance, help, and also for Chris for technical support. So the video of the webinar will then be made available to our CIBEL website, so you can watch it later as well. So please stay tuned for our future events, and I hope to see you again soon. Thank you, everyone.